Good morning, everyone, and welcome back to yet another session on polity and constitution. I hope I'm audible as well as visible. Great, audible and visible. Let's wait for those to join, and then we'll begin our discussion for the day. Okay, let's begin now, guys. In the previous class, that is yesterday, we had taken up for discussion, of course, judiciary, under which we are looking into the pendency of cases. What's the reason for pending cases, and how many pending cases are there, all such things. Then we saw how to resolve the problem of pendency of cases. Then some ADR mechanisms. ADR, alternate dispute resolution mechanisms. So ADR mechanism like Lok Adalat, Gram Nyayalay is also an example of such a mechanism. Then we saw judicial activism, a very important topic, under which we saw reasons for activism, some positive implications, right? Or also can be seen as somewhat of a justification for activism. Then overreach, also inaction. So all such topics, including PILs. So PILs, public interest litigation. Ideally, such cases are filed in the what? High Court and the Supreme Court. So that's it. This is sufficient information, way more than what is required for the examination. So, who is the mother of PIL? Who, not who. Which PIL? The Husainara Khatun case of 1980 is a mother of all PILs. Judiciary overreach. Judicial overreach is what we saw yesterday as a case where even if the functioning is of the executive and legislature is up to the mark, still the judiciary interferes and violates the separation of power without any need for it. Overreach. Court of arbitration. These are courts where any matter or dispute involving two parties are settled through primarily compromise by hiring experts from that particular area. A very classic example would be any dispute with respect to the seas, right? Water bodies comes under UN clause, UNCLOS, United Nation Convention, on law of seas, and if there is any confusion with respect to the water body belonging to or coming under control of which country, then you can go to PCA, Permanent Court of Arbitration. You'll be studying this in your IR classes when you study the South China Sea issue and the drama created by China in that area. Government shifts their responsibilities on the court. See, this is, as I said, a positive implication or a justification, because government also knows very well that if it goes about to implement some reform or a big ticket reform, it may not be appreciated by people, right? Because eventually people have this feeling that we have chosen the government. But if a law or if an executive order is enforced by the courts, then people can do nothing much about it, right? So, in certain circumstances, we have to also see that as a very positive implication, a justification for activism, and not judicial review. Activism. Judicial review is something different, activism is something different. Uh, Shriyank. Shriyank, Husainara Khatun is a very popular one, and PIL, mother of all PILs, is called Husainara Khatun case. And anyway, the very first PIL filed in the country under that zone, if it can be covered, is the Bombay Back Bay case of 1975. That is the first PIL which can be assumed to be a PIL. Okay, but the term mother of all PILs is given to Husainara Khatun. PIs are filed primarily in the high courts and the Supreme Court because it relates to what? It relates to upholding the rights of people. The lower courts are not allowed to issue writs on protecting fundamental rights. Rishabh, I think your question is self answerable. Lok Adalat gives awards. Those awards cannot be challenged anywhere. No, judicial invasion is more like judicial overreach. Okay. Yes, Nirbhay, Parliament can keep on amending the constitution. Right now, we have not seen that, but once you go to fundamental rights, you'll realize that for every judgment passed by Parliament, by the Supreme Court, the Parliament kept on amending the constitution to bypass the judgment. It's very common. Right? Yes, no fees for Lok Adalats. And complementary role with respect to parliament, meaning there are some situations where the parliament is unable to make a law because of maybe lack of a unity in the members, amongst the members, lack of common ideology amongst the members, right? So in that situation, the Supreme Court can issue guidelines. Sometimes the Parliament may not focus on a certain issue, so we still have the support of Supreme Court, which can issue guidelines, etc. Take the tough decisions, which are creating a confusion in the minds of people otherwise in the Parliament. In Lokayukt, Lokayukt is a different body altogether. What is Lokayukt? Lokayukt and Lokpal are different bodies. Are we clear? It has no relationship to Lok Adalat. Please, you'll be studying Lokayukt in your governance classes. It is a body, ombudsman at the state level. We do not need to know any kind of case story with respect to PILs. Just the judgment is sufficient. Okay. And PILs, as I said, can be filed in high courts and Supreme Court. Criminal antecedent means criminal background. So that's it. We had covered these classes. Now let's begin our discussion for the day. So, firstly, great that you have landed on the website today. or the app today on a Saturday morning also. Hats off to you and the focus and determination. Anyway, after this false motivation, let's move on. First up is a question asked in 2020 on PIL's judicial activism, etc. So today we have no practice questions. Why don't we have any practice question today? This is an extra class. Just like in the parliament. Whenever, I had mentioned this point also, that the question hour does not take place on two occasions. What two occasions? Number one, budget speech day. Number two, president's address. Question hour will also not take place if the parliament is sitting beyond the permitted time period. If there is any additional sitting that takes place on Saturday or Sunday to pass some bills, then no question hour. So we'll simply follow, right? Teaching polity through practical examples and experiences. Okay. So that's it. Now, coming to mains based question. Let's read this question. Judicial legislation is antithetical. What is antithetical? Directly opposed to. So, judicial legislation, very weird kind of word, right? Legislation is law making, judiciary making laws. Of course, it is antithetical, meaning opposed to the doctrine of separation of powers. Yes or no? Of course. I mean, judiciary making laws is directly against separation of powers. Law making power with the legislature only, as envisaged in the Indian Constitution. In this context, justify the filing of large number of public interest petitions. Public interest petition is nothing but PILs only. Public interest petition is just PIL. Praying for issuing guidelines to executive authorities. So question is very simple. Judicial legislation, judiciary making laws, giving orders which have the same force as that of law, is opposed to the constitutional idea of separation of powers, LEJ. Despite this, you please justify the need for filing large number of public interest petitions, praying for issuing guidelines. Simple. So, when it comes to the introduction, mention about the concept of locus standi. You can also mention how Article 142 allows the Supreme Court to provide for complete justice, right? Such things. In the body, firstly mention how PILs or judicial activism is violating separation of powers. Violates separation of power. You can also mention some problems. So, negatives. That is, sometimes it can result in overreach also. But then you have to justify. So, please write the positive implications, need for PILs or need for activism. You can also talk about the reasons why it is required. Reasons. Finally, in the conclusion, and give examples. Examples should be of two kinds. Some classic examples: the Husainara Khatun case, right? So such kind of cases which have been there, right, for a long period of time. Old cases, classic examples: MC Mehta case, Bandhua Mukti Morcha case, right? So such cases. Apart from it, mention some current examples, and then in the conclusion, talk about some checks checks on judiciary. How? Uh, the concept of restraint, judicial restraint. So, first things, I just summarize this point of what, and for all of you who want to also note down some points on what can be a very viable conclusion with respect to the a check on activism, preventing overreach. Judges have to always show statesmanship. You know, they need to uphold the rights of citizens, but without sacrificing on the sobriety. I mean, dignified behavior, sincerity. Then, judges should always exercise caution in off the cuff remarks, remarks in open courts, loose remarks, excessive frustration, because any remark made by a judge is susceptible to misinterpretation in the court. Then refrain from making any intemperate comments. Uselessly don't criticize other organs. In fact, the judiciary should refrain from over criticizing the other organs, the legislature and the executive. Then one very important thing is the judiciary has to limit itself, stick to what? Stick to the review of decision making process only, and not the decision itself. The country has executive and legislature to decide policies. Something as simple as that needs to be understood. You have to say no to judicial governance, right? There cannot be judicial governance in the country. Governance is something which needs to be done by the executive and the legislature. The judiciary should have no role to play in governing the country, right? And that is why uh, the summary of all this can always come down to the fact that the strength of judiciary lies in understanding its limitations. Yes, Article 142 gives you this wide, far reaching power to give any kind of judgment, but that should always be under the limitation of what? A self restraint, understanding your limitations. Because let me tell you, misdirected enthusiasm, over enthusiasm, is rarely consistent with impartiality. So, excessive enthusiasm is always seen as something not appropriate, be it for the judiciary also. So, like in the recent case where uh, the state high court denied bail, but Supreme Court's doors were opened, right? Normally, I'm not sure if it is open for common man in as easy a fashion as it was open for providing bail, and the judges making statements like the heavens won't fall down, right? So this is there. So eventually a very important element here is to understand the fine line between not crossing the boundary, limiting yourself, or crossing the boundary and interfering in the functioning of the executive or legislature. This is all about the question. Yes, the Teesta Chitralwad case only is what I was referring to. So anyway, so that's it with respect to this question. Please write the answer for this question. Or a question asked last year only. The most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss this statement with the help of relevant case laws. So, how has Supreme Court ensured solving environmental problems? Right. So, we had discussed some examples under PIL on environment. Mention those examples. Talk about how Supreme Court has said that uh, right to healthy environment is a part of Article 21. Slowly and steadily, Supreme Court has started ensuring started ensuring that the right of every citizen, every person in this country to a healthy environment, polluter pays principle, absolute liability principle, firecracker ban, right? Bharat Stage 4 norms, 6 norms, all such things. So we have seen plenty of examples. Mention those, intro, conclusion, all such things, and you are good to go. Okay. So that is it with respect to this question as well. That's why I said that mug up as many examples as possible. And I'm repeating once again that you do not need to know the case story. All you need to know is the case name and what was said in the case. That's it. Okay. So please take an attempt here also. Write the answer, get it evaluated. Okay. And let me also clarify one thing. If you are getting 5 marks out of 10, 4.5 marks out of 10, 4 marks out of 10, 5 marks out of 15, don't start getting desperate. After writing 4 questions, if you expect 8, 9 marks, then you are in the fool's paradise. Please understand, reality check is important. After reading everything, you will still not remember 9, 8, not 90, but 60, 70% of things. Constant revision is required, and even then you have to keep on updating and improving your content, and even then the evaluators have been told to be slightly more strict, and even then you won't be getting full marks. So don't have this misconception, right? So we need to understand that our priorities and of course our expectations are not misplaced. That not getting 7 marks out of 15 and I'm sitting home and crying, I will not write any more answers. No, that's not how it is. You have to keep on writing to improve. You don't go to the gym, start building muscles and take up a dumbbell and say, where are my 16-inch biceps? I want it today only. That's not how things work. It takes time. Okay. So that's it. Send all your answers to Target IAS, get them evaluated. What score is good? No score is good enough, and no score is bad enough. They can be worse scores, they can be better scores. See, on an average, our target has to be aim for the 40-50% zone. Aim for this. Out of the total marks allocated, 40-50% marks is what you need to score. Okay. Now, coming to the next topic at hand, tribunals. Now, what exactly are tribunals? Tribunals is a classic example of a Quasi judicial body. Quasi judicial body. A body whose functions resemble the functions of court of law, right? Semi judicial body, partially judicial body. How is it judicial? It conducts hearings. It will make findings of facts just like courts. It will apply governing laws. It will also draw conclusions. All that to resolve disputes. A very good example of a tribunal or of a quasi judicial body is the Finance Commission. Finance Commission is a constitutional example of a quasi judicial body. They can be statutory also. NHRC, statutory body which acts like a quasi judicial body because you are filing your complaint here. The body will look into your complaint, will conduct hearings, etc., make findings of facts, and eventually will apply laws, drawing conclusions, giving recommendations. Sometimes they can be regulatory also, like SEBI, Securities Exchange Board of India. All these are classic examples of quasi judicial bodies, which don't see them as typically as quasi judicial, but they are quasi judicial. In fact, a very good example would be, more examples would be Article 61. What is this? This is a quasi judicial process. So, impeachment, because you are removing the president, impeaching the president, this entire process of impeachment is a quasi judicial process. Clear? So, this is how any body or any process which resembles a process followed by the court is a quasi judicial process. And the same goes for tribunals. Tribunals are also semi judicial bodies. Semi judicial, partially judicial. Okay. And very important, all courts are tribunals. All tribunals are not courts, but all courts are tribunals. Understand this point? All the courts are tribunals, but all tribunals are not courts. This is said by Supreme Court in the Kyoto Holohan case, 1992. Kyoto Holohan. Do you remember Kyoto Holohan? Under which topic did we study Kyoto Holohan? ADL, anti-defection law. The presiding officer's power is not, is subject now to judicial review. So, this is with respect to tribunals. Now, the idea of tribunals is not new. If you go back, back in the 1920s, there was a Justice Rankin Committee. Justice Rankin Committee of 1924 also said the same thing, that this regular court system is not able to solve all the cases. Lot of pending cases are there. 1920s. This Justice Rankin Committee report was of 1924. So that report also suggested that we need to deal with the cases by creating alternative bodies which can be like judiciary. right? With minor differences. Now, later on, the first ARC, it recommended setting up something called a civil service tribunal, meaning a separate body, a court-like body, which can deal with all the cases involving civil servants. If any civil servant faces any problem in their entire career, you can go to court, but it will only delay the matter. So why don't we create a separate judiciary kind of body, a quasi judicial body, a tribunal, to deal with those problems? The problem of transfer, postings, promotions, demotion, salary cut, all these things, pension not being given, gratuity withheld, all these things. Later on, no, in 1972, Justice J.C. Shah committee report came out. Then in 1974, we had the 58th Law Commission report. All these recommendations from these committees pointed out towards one thing: creating tribunals, creating specific semi judicial bodies to deal with some very important matters. Finally, in 1976, through the 42nd Amendment Act, we added Part 14A. Part 14A was a part added based on the recommendation of Sardar Swarn Singh Committee. So Sardar Swarn Singh Committee report gave this recommendation, and based on this recommendation, we incorporated two articles, 323A and 323B. Now these two articles we'll see shortly. What do these articles say? But just to clarify, these articles did not create tribunals. They gave option to the parliament and the state legislatures to create tribunals by law. So this is the advent of the formalizing of the creation of tribunals. Now, why did we need the tribunals? Or firstly, what are the features of tribunals? See, the difference between a regular government court or a tribunal is that courts follow procedure, controlled fact finding, application of laws, Indian Evidence Act, all such things. Courts follow all these things. They follow rules, regulations, etc. Hiring of lawyer, calling of names, everything in a very formalized manner, which also sometimes becomes costly, which also is time taking. Whereas tribunals don't follow any such thing. They are authorities outside the ordinary court system which interpret and apply laws when the acts of government are challenged through formal suits or other established methods. So, whenever people want their disputes to be resolved, they can approach this semi judicial body also, because the purpose of a quasi judicial body is to conduct hearing. As I said, in the case of parliament, when the president's removal is taking place, the impeachment is going on, what is the parliament doing? It is acting like a court only, where some MPs are raising concerns, trying to prove how the president has violated the constitution. The president can send a lawyer on his behalf. The president can himself come and speak on his behalf, right? They make findings of facts. They apply the laws. What law are they applying? Article 61. And they are ultimately drawing conclusion whether the president is guilty of violating the constitution or not. So, tribunals. Now, what are the features of tribunals. Tribunals are semi-judicial bodies. It is not a court of law, but it enjoys some powers of a civil court. What is the power of a civil court? The power of civil court is the power to call anybody to be a witness, to seek submission of documents from anywhere in the country. That is the power of a civil court. Clear? Any body which is given the power of civil court, that body has the power to issue orders and call people to become a witness, appear as a witness. That body has a power to issue orders and ask anybody to submit documents, seek submission of documents on affidavit. So, as we said, it is generally free from all the rules of Indian Evidence Act, CPC, all these things. They don't follow all such things. They follow just one thing: principles of natural justice. That's it. If this is there, no problem. No need to hire a lawyer, all that drama, not required. Come, present your case, get a resolution, move out. Nobody cares. That's how easy it is to get an order in the tribunal. Now, tribunals can also review their own decisions. So, tribunals also have this power to review their own decisions. Clear? Okay. And anybody who has any issue with the powers of a civil court, please, if you want to refer to powers of civil court, go and read Article 338, Clause 8. It is mentioned there what are the powers of civil court in very complicated language, which I have explained in the simplest of language. Look at the recording of this live video again. Now, why did we need tribunals? See, firstly, understand tribunals are restricted to certain areas of expertise. With the passage of time, the governance has become highly technical, right? Governance is extremely technical in nature in the sense that the scope and ambit of governance has widened drastically. So it also you also need to understand that there will be a situation wherein the government is expanding its activities, venturing into commercial areas, growing commercial ventures, etc. Right? Areas of technicality, for example, environment. Under environment, we have NGT, National Green Tribunal, or we have for telecom disputes, settlement appellate tribunal. So, areas of expertise required experts to be members to provide for a more comprehensive uh, awards or orders, which could not be secured from courts because judges in the court may not have the requisite knowledge and deep understanding of a very technical matter, right? Also, to provide inexpensive and quick justice. That is also something that needs to be there. Providing inexpensive justice. As I said, no need to hire costly lawyers and all. You can represent your own case there, no problem. Quick, fast justice. Why? Because we do not need to follow any such procedure which is normally there in the court. So, it's an informal way to deliver justice. And the one very important reason for tribunals was to provide relief to the ordinary courts. Now you will see that lot of cases don't go to courts, they go to tribunals. What we refer to normally as unburdening the judiciary. Okay. Now coming to tribunals in India. See, if you ask me what was the first ever tribunal was IT80, Income Tax Appellate Tribunal in the country. Income Tax Appellate Tribunal. But constitutionally, if you read Article 136 and 227, you will find the word tribunal mentioned there, right? Supreme Court can can review orders given by any kind of court or tribunal within the territory of India. Now, that's the use of word tribunal with no definition, no context whatsoever. But the word tribunal was used. So some of our emotional aspirants will ask these questions. Is the word tribunal used in the constitution? They don't know why they ask these questions because UPSC never asks such kind of questions, right? It'll ask on a very concrete basis that definition is mentioned or not. But anyway, for those gimmicky questions, the response is this only, that yes, the word tribunal is mentioned in the constitution. That does not make it constitutional, right? The provision to create tribunals came up for the first time in 1976 only, not before that. Now, in 1976, the Indira Gandhi government modified the constitution and added provisions to create tribunals. Article 323A. This Article 323A, under which Parliament by law can create what? Tribunals for administrative matters. And under Article 323B, Parliament or the state legislatures can create tribunals for other matters. So, here in Article 323B, they mention the word appropriate legislature by law. Appropriate legislature meaning both state and the center. But 323A, the power belongs to center only. So, only Parliament by law can create tribunals for administrative matters. These two articles did not create tribunals. They said that if the parliament wants, it can create tribunals, opening the avenue to create tribunals. Later on in 1985, when Rajiv Gandhi was in power, he said, my mom has made a change. Nobody is creating tribunals. I will create tribunals. And because it was allowed, parliament by law could create tribunals. So the parliament by law did create tribunals to deal with what kind of matters? To deal with administrative matters. And the law is called Administrative Tribunals Act 1985. So, this Administrative Tribunals Act provides for three different types of tribunals. One is CAT. What is CAT? Central Administrative Tribunal, or CAT, is meant for central government employees. Then SAT. SAT is meant for, of course, state government employees. And then JAT, joint. If two or more states have a joint public service commission, which is not there, but if they have, they can create a JAT also. What exactly is the task of this CAT, SAT? CAT, SAT, etc. They deal with disputes or complaints with respect to recruitments and conditions of services of civil servants. Okay, meaning every possible situation wherein your remuneration, your salary, your pension, retirement benefits, confirmation, seniority, promotion, superannuation, all such things, right? In fact, your entry in the job also, right? So if you say that I am an eligible candidate for a government job, then you are allowed to file a case in CAT, right? That makes you eligible to file a case in the CAT. So even in entry in the job, if there is any biasness happening in the while you're in the job, in future some of the IS officers here, government employees here, you will be going to CAT only. Let's hope you never have to go to CAT, but you will be going to CAT in case your pensions are denied, retirement benefits are not given to you, your job is not being confirmed, you are still on probation, your promotion is denied to you, all such things. Clear? So this is with respect to CAT. Same thing for the SAT. Now, let me also clarify. CAT is meant for, I think we can use a better word here in order to avoid any confusion. Employment. Central government employment, state government employment. This would also mean that people of the armed forces can't approach CAT or SAT. People or officers or servants of Supreme Court, High Courts, they can't go to CAT. Are we clear? The Administrative Tribunals Act is not meant for armed forces and servants, officers of the Supreme Court, High Courts, and subordinate courts. For armed forces, we have a separate tribunal called AFT, Armed Forces Tribunal, right? So this is meant for only central and state government employment. Now, composition of CAT. CAT comprises of a chairperson, CAT comprises of a vice chairperson, judicial members, as well as administrative members. So, what is the qualification? Chairman. A chairman must be a former or sitting judge of the High Court. Judicial members can be former or sitting judge of High Court, or those IAS officers who were working in the Department of Legal Affairs as a secretary for 2 years, or an additional secretary for at least 5 years. Top two IAS posts. So at the top we have secretary, then we have additional secretary, then joint, then deputy, and then under secretary. The hierarchy of IAS officers at the central ministerial level. Such do SAJDU. Anyway, apart from it, you will have administrative members. And look at this membership. In CAT, the members comprise of civil servants. Civil servants. Please understand this point. Let's say I am a civil servant. I have a problem with my department. Meaning what? Government. The government has not given me promotion. Right? I am going and complaining to CAT or SAT. CAT or SAT comprises of government servants only, IAS officer, right? These IAS officers have allege their loyalty towards the government only. How can there be fairness? The membership is a big problem actually. The membership quality involving IAS officers is creating a sense of biases in the favor of government. Then, administrative members are people who have been secretary in the government of India or government of state for 2 years, or additional secretary for 5 years. Qualification. Now, coming to the appointment procedure. See, when it comes to appointment procedure, let me just clarify. These are old provisions, not new provisions. But then why have I mentioned the old provisions? I did not get time to update the PPTs. Of course not. That's not the reason. The reason is something you'll understand shortly. So the appointment of the members of CAT are done by president only, SAT also. But for CAT, in consultation with CGI, and for CAT CGI, for SAT in consultation with the governor. Now, term of office. The chairperson's term of office is 5 years or 68 years, whichever is earlier. Members 5 years or 65 years, whichever is earlier. Conditions of service, same as High Court judge, same kind of salary allowances, etc. And removal. Now, this is, we have seen one way of removing some people, like the Supreme Court judges, High Court judges, SEC, CEC, etc. They are removed uh, by the Parliament. By the Parliament. But the point is, there are some other important statutory, even constitutional posts, wherein the removal does not require voting in the Parliament. It only requires inquiry by Supreme Court. For example, CAT members only. If you want to remove a CAT member, all you need to do is complain to the president, and the president will then ask the Supreme Court to conduct inquiry. Supreme Court will conduct an inquiry and give the response, its opinion, whether the person is guilty or not, to the president. The president can then simply remove the person. So, this is removal after Supreme Court inquiry. Similar process used for UPSC and SPSC members, members of the Human Rights Commission, members of CIC, SIC, members of CVC, in fact, with some conditions. Lokpal, in some states, Lokayukt, in a few states. So many people, so many important posts, people here are removed in the exact same fashion. I just gave this example here only in case there's a question. You can mark the answer accordingly. So there's so many people or categories of posts which are removed in the exact same fashion. Clear? Including the members of your body, UPSC, SPSC. Now, coming to, and for those who have a problem with what is CIC and CVC, Google search is sufficient, or else I'm telling you right now, CIC stands for Central Information Commission, SIC stands for State Information Commission, CVC stands for Central Vigilance Commission. Okay, great. Now, When the tribunals were formed, originally, the tribunals awards were challenged only in the Supreme Court. The awards given by tribunals could be appealed only in the Supreme Court. But then this matter was challenged in the Supreme Court only. How can you deprive the high courts of their power to issue writs? How can you deprive the high courts of the power of review? High courts are also court of records. So Supreme Court in 1997 in the L. Chandrakumar case said that tribunals created under Article 323A and 323B are the courts of first instance in their respective areas. If you are a litigant, you cannot directly approach High Court. You go to tribunal first. So what is the procedure now? Case filed in a tribunal. If you are unhappy, then first appeal now goes to where? High Court. And second or final appeal is in the, of course, Supreme Court. But let me also clarify this point. If in a certain area, certain domain, we have created a tribunal, then you cannot simply go to the what? High Court or Supreme Court directly. For example, if you are a central or state government employee and you are facing some problem with respect to your say uh, promotion, your promotion has been denied to you, right? Okay, you are facing a problem there, you say this is unfair, not correct. Can you go to high courts? No, you can't go to high court directly. You have to go to the concerned tribunal, cat or sat. Clear? So if a tribunal has been created for a certain respective area, the tribunals will be treated as the courts of the first instance, meaning you have to go to tribunal first, right? Then appeal in the High Court or the Supreme Court. Okay, that's it. Now, some nice things, advantages of tribunals. See, as far as tribunals are concerned, they are great bodies. They follow flexible procedures, right? No ordeals of the uh, evidence acts. They simply follow principles of natural justice. No need to follow any rigid procedure. Secondly, they provide efficiency in dispensing justice. Why? Because they are cheap, they are time effective. They also unburden the judiciary, though sadly, uh, now we don't really see that happening too much, because after the L. Chandrakumar judgment, the tribunal's awards can be challenged in high courts also. In fact, the real reason why we had tribunals was to unburden the high courts. Even now, the real concern is pendency in high courts, because high courts are the court of almost final court of appeal. Supreme Court is not meant for everybody, right? Supreme Court is meant only for the rich and elite. Sorry, Supreme Court is meant only for very important cases, right? Supreme Court is only meant for cases which are constitutional matters, etc. So you cannot directly go to Supreme Court, or not every case goes to Supreme Court. So the real problem initially 1950s also was a pendency of cases in the high courts. And the first law commission also had been saying that we should create tribunals to unburden the high courts primarily. But the L. Chandrakumar judgment, using the argument of court of records, Article 226, it said that high courts can issue orders on any matter. How dare you take away their power? High Court, Supreme Court, all same. So that has become a problem. Anyway, then we saw this yesterday A big problem with activism, uh, which is sometimes also seen as an overreach, is a problem of specialization, expertise. Judges don't have expertise. So when a tribunal gives an order, what is going to happen is, simple example, National Green Tribunal. This NGT was created or established in 2010. NGT Act 2010. NGT has its benches, right, in New Delhi, Bhopal, Calcutta, Chennai, Pune, five different places, right? And NGT comprises of a chairperson, some judicial members, and expert members, 10 to 20 full-time members who are experts, right? So experts are members who have knowledge, vast experience in that field. That is why, for example, Supreme Court has also shown a lot of respect for these tribunals, considering their membership involves experts in that field, right? So the purpose, as Supreme Court has said for NGT also, is that NGT plays a complementary, competent, or NGT is a complementary. It's a very competent, it's a very specialized forum to deal with all environmental multidisciplinary issues, right? And in fact, Supreme Court has told NGT that NGT, you should not wait for people to file cases. Take up suo motu cases also, just like courts do. So much of respect is being shown by the courts to these tribunals, that since you have experts, you are in a better situation to provide for verdicts or awards or orders, right? So this is there. So yes, there are members who are specialists, ensuring that they better appreciate the technical nuances of a law. And once they give an order based on certain facts, based on some reports, and when you challenge the award in the High Court or the Supreme Court, the High Court and Supreme Court judges will rely on these reports based on which the award was given. Because after all, the tribunal is following natural justice. It has to give reasons for its awards. The courts at the higher levels can look into the reasons. Nice things, advantages. But then come the challenges for us, problems. See, first problem is not really a problem, but a misconception largely. Some people believe, and when I say some people, any proper government structure is not appreciated by only one group, the left wing liberals, pseudo liberals. They're not liberal people. They do not accept anybody else's point of view. Liberal views means you accept other person's point of view, also respect that. Okay, it's your opinion, you are free to have your own opinion. Empathy is important. In our country, the so-called left-wing liberals, so left and right is a very simple concept. We try to further create divides in left and right for our understanding, but just understand 2 points. If you believe that a group is more important than an individual, you cannot compromise a group just for the sake of an individual, you are a right winger. Okay? Nationalists, people who support a religion, people who support their own caste, their own language, they're all right wingers, because you believe the importance of a group over an individual. A left winger believes that what is a group if not a sum of all individuals? So individual rights are more important than group rights or collective rights. Left wing. Now you see, this is a very generic definition. And if you try to place political parties here, then it can't be done on a linear pattern, because some political parties also claim to support rights of poor, downtrodden, individual rights. Parties will also support their language, the linguistic group, the caste group, the religious group. So they keep on moving here and there. They keep on shifting here and there. So this is it. So the problem here is that when it comes to right or left, now you can place yourself where you belong to. If you feel that an individual is way more important than any collective right of any group, then you are in the left. Or if you believe that no, uh, the group, uh, they are more important than an individual, then you are in the right. Yes, you can call yourself as a centrist also, right? Trying to play it safe, that it depends. And frankly, it depends also. On certain occasions and situations, a group right is more important. A group is more important when it comes to a nation, right? When it comes to culture, you have to find the balance. Yes, we respect an individual, but we cannot compromise on the nation's integrity also. When it comes to issues with respect to providing basic needs of life, and individuals' rights are very important, right? Again, fine balance. So, one such allegation leveled by the left wing and in general people here is that this tribunal is a very unique way, where a very cunning way, where the governments try to encroach upon judicial functions, because normally judicial functions, giving judgments, orders, left for the courts. You can't interfere in courts functioning. That's a problem, because courts are independent. How do you create an alternative court which is controlled by you? Members you choose, you appoint. Here there is no collegium system. Here the government is appointing people, right? So what happens is, I will create a tribunal on that matter, and I'll create parallel judiciary in the country. So this is with respect to an allegation, though largely misplaced, because the creation of tribunal, and now tribunals awards are challenged in High Court and Supreme Court. What's the problem? The only way you are coming out of it, or you are excluding yourself, is from the lower courts. And lower courts by no means are very independent bodies. Okay. So first thing that is the allegation is what? Tribunalization is happening in the country, which is called, or which means encroachment upon or of judicial functions. Judicial functions by tribunals. This is called tribunalization. It's just a joke, but again, one allegation is there, so we need to at least understand it. Now comes the beauty of tribunals. See, we are constantly saying that tribunals are like courts which give orders, quick judgments, because there is no need to follow entire procedure, Indian Evidence Act, calling names of people, providing evidences. Something as simple as when you provide evidence in court, right? In the movies they always show that when you give any evidence, some witness is being called, right? The entire court is shocked. Witness walks from the back of the court, right? So the entire court is shocked. New witnesses come. Everybody is surprised. The judge is surprised. The other lawyer is surprised. Now you can't surprise the court. It's not some joke, right? That surprise everybody. New witness. No, you have to inform the other party and the court of any new fact or evidence you are tabling in the house. And the other party, other lawyer, has to be given sufficient time to understand, read, absorb, comprehend the evidence or fact. Are we clear? This is as per the Indian Evidence Act. These things take time. That is why delays happen. Some copy was given, new evidence. I am the other lawyer. I received the copy. When the next date came, I am not prepared. I'll say, sir, when I got the copy of the evidence, the fact, some evidence, the photocopy was not clear. I could not understand and comprehend last 5 lines. Next date, please. I will get a better photocopy and then read it. Next date, adjourned. So these are loopholes, right? So this is with respect to the Indian Evidence Act. Of course, the judges can allow for you to submit evidences on the spot also, but those are rare circumstances. That does not happen in 99% cases. But here, no such limitation. Free, quick, fast. Really? What fast are we talking about? I'll give you examples. Pendency of cases here also. In the Central Administrative Tribunal, as of now, 17,000 cases are pending. 17,000. It used to be more than 40,000 till recently. It has come down drastically. In the Income Tax Appellate Tribunal, ITAT, 92,000 cases are pending. In the Railway Claims Tribunal, RCT, 46,000 cases are pending. In the Custom Excise and Service Tax Appellate Tribunal, 91,000 cases are pending. In the DRT, Debt Recovery Tribunal, 78,000 cases are pending. What the disposal is quick are we talking about? Here also pendency is there. The problem is the population of the country. We are extremely highly populated. So wherever you go, pendency will always be a problem. Too many people. What can we do? Right? The government did not take any proactive steps to tell us to control population. In the entire 1950s, 60s, 70s, 80s, people were ill informed. Let's have more kids, more hands to work. And now the burden. So, a lot of you would realize this through your family members only, parents, grandparents, 5 brothers, 6 sisters, 7 brothers, 8 sisters, some kind of rugby team, cricket team. That has had a repercussion now. Now, your parents have had 2 or 3 kids and all. You may have 1 or 2 kids. So, that is there. So, of course, it may not be really a problem of tribunals only per se, but yes, pendency here also. Then, violation of separation of power. Classic example, NGT, National Green Tribunal. So this tribunal, NGT, this NGT's task is to issue orders, orders to ensure that the issue guidelines to ensure that environmental uh, damage is not done, and it constantly issues guidelines just like legislature. Like legislature, it also has the task to implement laws like the executive. There are so many laws which are implemented by the NGT. I think except Wildlife Protection Act and the Scheduled Tribes and other forest dwellers, their Forest Rights Act, that is of 2006. Barring these two laws, all laws you can think of with respect to environment conservation, Water Prevention and Control of Pollution Act 1974, the CES Act of 1977, the Forest Conservation Act of 1980, the Air Prevention and Control of Pollution Act of 1981, Environment Protection Act of 1986, right? The Biological Diversity Act of 2002. Every such law is implemented by the NGT only. Clear? Now, if you do not follow the law properly, then what happens? NGT can also impose penalties. The penalties can range from fine to even jail sentence for non-payment of fines with the approval of Supreme Court. And let me just remind you, the fine is not like the other fines you see in the IPC, 100 rupees, 1000 rupees. The fine can be up to 10 crore rupees. Yes, yes, you heard me right. Up to 10 crore rupees. Plus any compensation for the damage you had caused. Right? Plus extra fine of up to 10 crore rupees. Like a few years back in 2016-17, I believe, Sri Ravi Shankar, Art of Living, not sitar player Ravi Shankar. So Ravi Shankar, he had organized a Art of Living function, right? And in that function, what happened? Lot of environmental damage was caused to the Yamuna River further, and the Yamuna floodplain, which violated environmental norms. And NGT imposed a penalty of 5 crore rupees on the organizers of the Art of Living festival, right? So, all three things, LEJ, all in one. Where is the separation of power? There is no separation of power. One more thing. For NGT, NGT is as of now very unique in the sense that NGT awards can be challenged only in the Supreme Court, not other tribunals. Other tribunals awards can be appealed in high courts, L. Chandrakumar case. But NGT Act specifically says that the NGT awards can be challenged in the what? Supreme Court only. NGT has a task to ensure that people follow these guidelines properly. Okay. Then, one very important thing, independence is compromised. Look at the membership. Membership, appointment, or the eligibility of members, government control. So, independence is compromised. Then, allegations of corruption. There are so many allegations of corruption against various tribunals. A very classic example of allegation which normally happens is you are a government employee, retired government employee, because of some issue, and that can be a very trivial issue. Date of birth not matching, such kind of issues. Your gratuity, your pension is not being released by your department. You approach the cat, some bench of cat, right? And if you approach the cat, the allegation that one member of cat says that give me 2 lakh rupees, I'll give an award in your favor, asking your department to give you pension immediately. These allegations are very frequently made against the members of CAT. Or there used to be a body, now it has been abolished, called FCAT, Film Certification Appellate Tribunal. So whenever you want to release any movie for public exhibition, basically releasing a movie in theater, there's a certificate that is displayed in the beginning of the movie, right? With the rating given. That certificate is given by a body called CBFC, Central Board for Film Certification, right? So, there are four categories of certificates given. Primarily in our country, you will only know three categories. The fourth one is for restricted access only. The first one is universal. Movies like Chota Bheem and all these things, or all the Hum Saath Saath Hain, Vivah type of movies. Second would be the UA, Universal Access with Adult Supervision, PG-13 kind of movies. So all the typical Shah Rukh Salman kind of movies, family entertainers with a bit of violence and all these things. Then you have the adult movies with coarse dialogues, maybe lot of bloodshed, maybe lot of depiction of sexual scenes and all, adult movies. So if you have the problem is, if I want my movie to be released, the biggest box office earners are the movies which are UA or U category movies, because families also come there. Adult movie eliminates the family part. Families won't turn up. Money is not collected. That's why you won't find Imran Hashmi's movies getting 400 crores. He has had a lot of hit movies, but not in that level also. Very difficult. So that's the problem. So every producer wants his movie to get a U certificate or UA certificate. But if the certificate is not given, then you approach the FCAT, Film Certification Appellate Tribunal. And there are allegations by these producers that FCAT demands money to give a more lenient rating to the film. That's there. Then vacancies here also. For example, look at CAT only. CAT has 42 out of 69 seats in various benches of CAT are vacant. 42 seats are vacant. Not 27 are vacant out of 69. 42 are vacant. More seats are vacant. That's the amazing performance of our tribunals and the government appointments. Then lack of infrastructure in these tribunals. You go and look at the tribunals. It's a very interesting. Such is the stupidity of the government's creation of tribunals. Awards of CAT can be challenged in high courts. Like the awards or the judgment of lower court can be challenged in high court. Judgment of high court can be challenged in Supreme Court. So we have lot of lower courts, few high courts, one Supreme Court. Pyramidal structure. Because when you appeal, lesser courts are required at the top. How many high courts are there? 25. How many CAT benches are there? 17 only. There are more high courts where you can appeal than the lower level courts, which are tribunals. Lesser CAT benches, more high courts. So that is there. Anyway, then their functioning is completely opaque. Look at the website. Websites are routinely unavailable. There have been situations where I had to get some information. I had to wait for 2-3 days. Every day I would click on the website at different times. Website under maintenance, cannot be accessed, right? Non-existent in most cases, unresponsive, not updated, old information, that is there. So these are some of the problems with respect to the tribunals and their function. Anyway, lastly, coming to a very interesting piece of current news, which is Tribunal Reforms Act 2021. So this law was passed. Now let me just clarify. Firstly, I'll explain the law and I'll explain what exactly was the sequence of events, which is what is the interesting part here. So this law was passed to bring about a change in a reform in the tribunals conditions. So firstly, the government said that in our country there are so many tribunals. In most cases, people don't even approach the tribunals. They always try to approach High Court, filing a request that High Court, please take my application. It is very urgent. Supreme Court, take my application. SLP. They use all these tools to evade the tribunals. What's the point? Remove tribunals. So the government abolished 9 different kind of appellate tribunals. Okay. Some examples like these were abolished. Number 2. Now, tribunal members will be selected. The recommendation, appointment by the president only. But the selection will be done by a committee. Search cum selection committee. This search cum selection committee will comprise of CJI, who has a casting vote. What is casting vote? Tiebreaker vote. If there's a tie, CJI will decide the tiebreaker. Then 2 secretaries, IAS officers, nominated by the central government. Then the sitting or outgoing chairperson of the tribunal, he will be a member. And the secretary of the ministry under which that tribunal has been formed will be a member. These people, 2, 3, and 4, these 4 people will recommend names for the appointment to the members of tribunals. Tribunals like CAT, tribunals like NCLAT, TDSAT, DRT, all these kind of tribunals. Now, for every vacancy, this is okay, no problem. There is a committee which will make recommendations, very good. Yes, the membership can be a question because you are involving government officers, which means government is appointing directly. Why this drama of having a CJI or judge, etc.? But anyway, now comes a funny part of it. If there is a vacancy, this search cum selection committee will make recommendations. For every vacancy, they will recommend 2 names. 2 names for every such post to the government. And the government must, not must, government will take a decision, preferably within 3 months, which name to choose. Preferably? What is preferably? Preferably, if I should, uh, but if I cannot, then no problem. Imagine you say, oh, I will try to study 10 hours tomorrow. I'll be studying preferably for 5 hours tomorrow. This means 0 hours. What is this nonsense of preferably? But if the search cum selection committee has told study, right, said appoint, appoint. What is preferably? This means never. They keep on recommending names. You keep on saying, no, 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 not this person. Next. So the whole purpose of an SCSC, the search cum selection committee, fails. Anyway, next. And you must have not seen this provision anywhere. Most unique provision. As if I ask you, what is the minimum age to be a High Court judge? Minimum age. Tell me, what is the minimum age to be a High Court judge or a Supreme Court judge? Somebody would write something. 25, 36, 35. Very good. 35 and 32. Create some more answers. 165 is the minimum age. Amazing. There is no minimum age. Don't. How do you create such things on spot? No minimum age. President's minimum age is mentioned at 35. But beyond that, or the vice president, for judges, for prime minister, it's not mentioned. And especially for judges, attorney general, it's not mentioned. But here, there is a minimum age of 50 years. So my point is, what is so magical which happens at the age of 50? I mean, the tribunal's awards are challenged in the High Court. There is no minimum age for High Court. But for tribunals, we have 50 years. Makes no sense. I mean, at the age of 49, you are completely stupid, unaware of what is happening. You turn 50, suddenly you have the knowledge to be a part of a tribunal, right? So, no, no, no. Secretaries are at the age of 60, 55 to 60. It's not 50. So, that is there. Now, third point, term of office. Back in 1980s, there's a very old judgment, Sampat, SP Sampat Kumar case. It's a very generic kind of judgment, which is applicable everywhere. SP Sampat Kumar case says that the tenure, the time period of any important independent official needs to be long, not short. Shorter tenures violate their independence. Because when you have a shorter tenure, then you are more likely to depend on the government if there is a possibility of reappointment. So what happened is that earlier the tenure used to be 5 years. Now it has been reduced to 4 years for chairperson and members. And look at this, they are now eligible for reappointment, meaning tenure reduced, but you can be reappointed if you perform well, give all judgments in favor of the government. Sorry, if you perform very well, giving fair judgments, fair awards, then reappointment. So this is in direct violation of a Supreme Court judgment actually, SP Sampat Kumar case. But anyway, that's not the point I'm trying to make. I'm making a different point. Let's come back here. Did we all understand the provisions of the new law, Tribunal Reforms Act? Everyone? Now let's come to the real catch here. Please follow me carefully. This law originally was introduced as an ordinance because this law was introduced after the budget session was over. during the recess of the parliament. So ordinance was brought. So originally it was a tribunal ordinance. Now, when this ordinance was brought, the ordinance itself was challenged in the Supreme Court by the Madras Bar Association. That three things are a problem. Problem number one, this. Number two, this. And number three, these two. And when this was challenged in the Madras Bar Association case, Supreme Court struck down these three provisions as unconstitutional. Are we clear? So, struck down by Supreme Court in the ordinance. But every ordinance has to again be tabled in the House and be brought as a bill. Government tabled the ordinance when the parliament met. And now, if you are the government, please tell me, when you bring the ordinance in the form of a bill, will you add these provisions again or will you remove them? You'll remove them because the Supreme Court just a month back has cancelled all these provisions. So I should remove all the provisions and bring the old ones back. Okay. The government brought the exact same provisions which were there in the original ordinance, despite just a month prior to the bringing of this ordinance in the House. The three provisions were deemed to be unconstitutional. Government said we don't care, and they brought the original ordinance in the House, got it tabled, got it passed also. Okay, got it passed. Now again this matter is pending in the court. Now the matter is, how dare the government bring the exact same ordinance as a bill, exact same provisions again, which were just a month back cancelled by Supreme Court as unconstitutional. Now let me tell you something here. There are three major problems. Number one, short tenure of members, along with provisions of reappointment of members. It increases the influence and control of executive over the judiciary. Number two, the minimum age of 50 years. It is a classic case of restrictive qualification, restricting the people from becoming members because of age of 50. There is no scientific proof or evidence collected ever to state that there is some kind of different level of maturity attained at the age of 50. Then, when you abolish certain tribunals, like the tribunals like these were abolished, what has happened? All the pending complaints in front of these tribunals was transferred to the high courts. You are only increasing the burden of the high courts. So on these three grounds, there are some major issues. And again, the Madras Bar Association has filed a case in the Supreme Court, which is pending since 2021, that the Supreme Court is yet to decide whether the Tribunal Reforms Act is unconstitutional for reenacting provisions that were struck down in the Madras Bar Association for violating the independence of judiciary. This case is pending. Government said we want more time, and the court gave it time. Why? Just 2-3 months back, you have cancelled some provision after a proper judgment. Why suddenly a change of heart? We constantly are focusing on this idea that people should be given ample time to provide for their side of events. That's okay, but not the government with all its resources. Time bound presentation of their side of events is a must. These are just loopholes misused by the elite lawyers and the government and rich people to bypass justice of any kind. It makes no sense to keep sitting on this particular matter. So we'll see. Maybe one fine day, I'll be teaching your kids that finally the judgment has come under Tribunal Reforms Act. and this is what the government court has to say, right? So we never know, right, when the judgment will come. That's it. That is why I had mentioned the older provisions also. Why? Because if the new provisions are cancelled, then the old provision comes back to par. Okay, that's why I mentioned this also, because the new provision the cancelled, we come back to the old provisions. Clear? That's all. We are done with the tribunals. So currently, this is the situation. The Tribunal Reforms Act 2021 is valid. Okay, it is valid. It is applicable in the country. It is fully functional. When the court decides, we'll see whether they cancel it or they succumb to the government's pressure and allow for the provisions to continue. Okay. So UPSC was till 3 years back, they were obsessed with tribunals. That's the beauty of UPSC. They catch some topic, become obsessed with it for 3 4 years, keep on asking the same question again and again and again, and then forget all about it. So they exhaust the topic completely and then move on. Now, the question says, how far do you agree with the view that tribunals curtail the jurisdiction of ordinary courts? How far do you agree? In view of the above, discuss the constitutional validity and the competency of tribunals in India. Now, question is very easy, but what we can do is we can write this question in two different structures. One is your typical intro body conclusion format, where you talk about tribunals, the definition. Okay. Then you talk about in the body how tribunals are curtailing judiciary. So they are not actually, they are only aiding the judiciary. Secondly, mention the constitutional provisions and constitutional validity, giving support that Article 136 also refers to tribunals. So that's there. And number three, discuss the uh, competency. So evaluate the functioning of tribunals, writing about what is good with them, what are the issues, and then in the conclusion, give some suggestions, filling up vacancy, funding the tribunals, etc. All these things. This is your standard intro body conclusion kind of structure. But in such questions, which have three different questions, we can also use an alternative way to write our answer, right? It can be three paragraph structure also. Paragraph 1, para 2, and para 3. And there is no need to have equal size of all the paragraphs. It would depend. So first paragraph mention how the tribunals are being seen as curtailing the judiciary, how we are facing allegations of what? Tribunalization. Okay. Second paragraph discuss the constitutional provisions, and third paragraph is the evaluation of the competency. Now, should we use the three para approach here? Can be done. See, the idea is to mix and match, but don't start using the three para approach in your first few answers only. Firstly, have full command and control over intro body conclusion standard, because this is the structure which will work in almost every question. This kind of structure works in those questions which have multiple sub questions, which no coherence, right? So independent questions. So this suits very well and will also create a kind of a distinctness in your paper, where the evaluator is not bored after reading the same kind of format. So you also throw in some interesting elements in your answer writing, trying to create a diversified structure of writing answers, which also separates your answer from other people's answer. Okay, that's it. So that's it. For curtailing the judiciary tribunalization, how it is being seen that the government has tried to create a way in which they take care of certain judicial functions, right? By roping in members from the civil services who they can control. And now, originally, the tribunals were seemingly were seen to be bodies whose awards could be challenged only in the Supreme Court, bypassing even the high courts. NGT still is a tribunal which can only have its awards challenged in Supreme Court, and then conclude in that paragraph by saying, however, after L. Chandrakumar case, such issues or such allegations are misplaced because now the tribunals simply bypass the lower judiciary, which anyway do not have the expertise to handle such issues. Okay, so this is again a way to, I just showed this question because you can use the three para approach also sometimes in your answer. But I would again advise you to please follow intro body conclusion, have full command over it, and only then move to experimenting. But experiment, it is important. Okay, please. We have to find innovative ways to get capture the attention of the evaluator. That's it. We are done with our judiciary, which also brings us to an end of our discussion on LEJ. We are done with half the syllabus. In fact, we are done with most important elements of our entire syllabus and the studies, LEJ. Now, what remains is smaller topics, which we'll cover one by one. Okay. So, when it comes to studying Lakshmikant, chapter 26, 27, 28, 29, and then 34, 35, 36. 27, 28, 29, then 30, 31, 32, 33 are for state legislature and executive, and then 34, 35, 36. 37 is for special category states, 38, 39 is for panchayats and municipalities. Important articles: 124, 129. So I have found one thing, that you guys are not reading the articles I tell you, the important articles. I mean, some of you are not reading the articles on your own. The purpose of me telling you these article numbers is for you to read these articles on your own. Otherwise, it makes no sense. I have already mentioned the article and the point. You can mug up the point, but you need to read the articles on their own also to develop a language, right? Because when I see some questions, especially via mail and here also, I see that you are asking a question which is directly quoted in the article, right? So read the article, very important. 131, then 132, 33, 34, not really important for the examination. 136, 137 is important. Of course, 139, capital A, transfer of cases happens a lot. 142, 143, 145. Then come to our high courts. 215 is court of records. See, 216 not really, but 217 can be remembered at least. Okay. Then Moving on to the lower judiciary, 233, 234. Then coming to the independence of judiciary, I had told you 121 as an article, right? I will not mention here 32 and 226 because these two articles will be covering under fundamental rights. So ignore 32 and 226 for now. Then 323 capital A, 323 capital B. That's it. No schedule here because we have already covered schedule 2 and 3 earlier only. Important cases, of course, the judges' cases. All the judges' cases and also the popular fourth judges case of NJAC. Then examples of PILs. Now there is no limit. It depends on you, right? It totally depends on you. Uh, with respect to how many you can mug up. Then the L. Chandra Kumar of 1997 and of course the Madras Bar Association case of 2021. Okay, that's it. How to find articles? I need to calm down first. In the very first class, I had mentioned this book, Constitution of India, right? So there you have various publications. You can take a copy of those, or if you say no money, right? So you can actually download a PDF from the Government of India's website, legislative.gov.in website, free of cost. Read the original article. Nobody will explain the bare acts to you. Okay, the article mentioned there, that is sufficient. The topic is explained to you already. You know it. Okay. Family code. Family code is not important. Uh, Understand this point here. So many things I teach are not mentioned in Lakshmikant, but they're important for the examination. Some things I ignore, which I mentioned in Lakshmikant, are not important for the examination. Lakshmikant is not a book for examination. It's not a book prescribed by UPSC. It's just one of the books which any aspirant can study to have a wholesome understanding of the syllabus. So UPSC does not prescribe Lakshmikant officially, right? Because why did the book become popular? Because it simplifies the very complicated language of the Constitution. That's the beauty of the book, right? So this is it. Uh, in the Lok Adalat pre and post litigation stage, Gram Nyayalayas are basically Nyayalay. They are courts. Lok Adalat is not a court per se. It is just a way to settle disputes through peaceful compromise. That is why the case can parallelly run in the court also. But Gram Nyayalay itself is a court, right? So you cannot file a parallel case somewhere and then go to Gram Nyayalay. That is not allowed here. Okay. We are done with our understanding of judiciary. Let's take a long break of 16 minutes. Full enjoyment of 16 minutes. Come back at 8:05 and then we'll continue our discussion on the topic elections. Sorry, 9:05. Break, please. Ashwant, judicial overreach can be resolved. I had discussed while giving you the answer for that question. You'll have to go back to the recorded video and see that when we were discussing that question, I had mentioned what steps can be taken in the conclusion for judicial activism, applying restraint, showing statesmanship without sacrificing on dignity and sincerity, upholding rights of citizens, avoiding judicial governance, understanding your limitations, right? Limiting excessive criticism, all such things. From which website to download Constitution of India? Very good question. Very good question. Uh, legislative.gov.in. High Court judge retirement age. Why are you asking all these questions? I don't understand. I mean, factual question. 62. Bar provision. What is bar provision? I'm not able to understand. Uh, Sir, exam will be conducted. Semi and quasi is exactly the same. Allegation of corruption. I had explained this point, giving an example of entirely of this FCAT also. No Sejal. Firstly, it is not possible only to mug up the articles as they are mentioned. You have to remember the context of the article, the crux of the article. Provisions of Bar Council. Why do you have to know Bar Council? Their Bar Council, State Bar Council, National Bar Council, they have their own provisions. Group of lawyers, they formed a council. That's the Bar Council. That's it. Palak focus excessively on static portion, less on current affairs. Okay. So now let's move on with respect to the elections in the country. Elections. Firstly, we'll understand some of the provisions pertaining to election in the country. For example, four primarily the four major articles that we have in the Indian Constitution. Article 327 and 328. Parliament can make laws in connection to all the matters relating to the elections for either House of Parliament or the state legislature. Parliament can make laws. Of course, Parliament is the competent authority to make laws on dealing with matters pertaining to elections. Fair enough. But the question is, can the states also make laws? Yes. The states can also make laws on all matters dealing with elections for the state assembly, state councils, not for parliament, right? But on those areas only where the center has not made a law. So if a law exists at the central level for Lok Sabha election and there is no corresponding law at the Vidhan Sabha level, then for that particular area, the respective state legislatures can also make laws on matters pertaining to elections. For example, think of it like this. Let's say you have the parliament elections, state legislature elections. If the parliament has made laws on five different topics for the Lok Sabha elections and four topics correspondingly for the Vidhan Sabha elections, then on that topic where the a law exists for the Lok Sabha election but no law exists for the Vidhan Sabha election, then here the state legislature can make laws. So UPSC won't ask you in this detail. They'll simply ask you a statement. State legislatures can make laws on matters with respect to elections of state legislature. Yes or no? Yes, they can. Now coming to, uh, I think in your history classes, in your school days also, you'd have known of a term, separate electorate. What the hell is this electorate? Electorate refers to voter, elector, voter. Separate electorate, meaning separate voter list. So in our country, there is no possibility of having a separate voter list on the basis of religion, race, caste, or sex, gender. Meaning, you cannot have a voter list where only men are allowed to vote, only Muslims are allowed to vote, only some caste is allowed to vote, etc. That's not possible. On these four grounds, you cannot create a voter list. Other grounds, it can be created. So, can we have a voter list on the basis of age? Yes, we can, and we do. We do have the voter list on the basis of age only right now. Can we have a voter list based on education? Yes, we can. In future, it's possible that the laws can be modified to say that now only people who say are uh, have a 10th pass certificate, 12th pass certificate, they are allowed to vote. A graduate would be too harsh, right? So this is with respect to the voter list. So there is no provision for separate electorate in independent India now. That's not possible on the grounds only of religion, race, caste, or sex. Now, coming to Article 326. Uh, this article is the most misunderstood article because lot of people including our great UPSC also thinks that this article gives us the right to vote. This article does not give us any right to vote. This article only gives us the right to be a part of electoral roll, that is voter list. So if you are above 18 years of age, right? If you are above 18 years of age, then you can be given or you are allowed to be a part of voter list. That does not mean that you have to, necessarily be given the right to vote. Your right to vote comes from a separate article, separate provision. We'll discuss it shortly. Okay, Article 326 only gives every Indian citizen above the age of 18 a right to be registered in the voter list. Are we clear? Universal Adult Franchise, UAF. Voting right for all adults, UAF. And the voting age is how much? The voting age is 18 from 21. So we are done with these provisions. Now let's move on and understand the Election Commission of India, the body, the task of which is to do what? Conduct elections in the country. Currently a three-member body, Shri Rajiv Kumar, Anup Chandra Pandey, and Shri Arun Goyal. The three members, with him being the Chief Election Commissioner, other two election commissioners. Okay, and a good thing, uh, today's motivation is that all these three people are retired IAS officers, right? Bihar cadre, UP cadre, etc. So all retired IAS officers. So one more opportunity for you to get a job after you cease to be a civil servant in the country. perform your tasks properly in the favor of the government, in the favor of people of the country, work for their benefit, and then if your tasks are very good, then the government of the day could appoint you to the post of election commissioner. So, Election Commission of India, Article 324. Okay, article important, constitutional mandate. Moving on to the appointment. How are the election commissioners appointed? One more thing, this election commission as a body was set up in 1950 on the 25th of January. Okay. On 25th of January 1950. And this date is now celebrated as what? National Voters Day. Okay. So the appointment is done by the president. Now, the parliament can make any kind of law and provide for the appointment procedure. But so far, parliament has not made a law. Until the parliament does not make a law, the president, meaning the government, will appoint the election commissioners. Clear? Such independence for the election commission, that the government directly appoints the election commissioners. Now, how many election commissioners do we have? One is mandatory. It's mandatory to have a chief election commissioner. Election commissioner. And if you have other election commissioners, then the one mandatory person is called the chief. So, the election commission shall consist of one chief election commissioner and such other number of members. So, CEC, the chief election commissioners, plus how many ECs? This number X, not the X you are thinking about right now. This X is a variable, can be anything. This X, the president may from time to time fix. This number is decided by the president. Okay? Decided by the president. Please don't ask me, sir, is this discretionary power of president? Nothing is discretionary power of president. Why should we come every day and make fun of the president? She is the topmost post in the country. So let's ignore that. This is all government's power only. So one CC is mandatory. How many ECs? It depends on the what? Central government. So currently, we have CEC plus 2 election commissioners. This is the case since 1993, though in 1989 also, for a small period of 3 or 4 months, we had 3 election commissioners, as in 1 plus 2 election commissioners. But right from independence till 1989, right, we had only one CEC. So X, the minimum value of X is 0. As somebody says, what is minimum and maximum? Minimum of X is 0, of course. We can have 0 also. From 1950 to 1989, we only had one election commissioner. Maximum, the president decides. 1 crore also. So this is our current situation. Clear on this? Basic information, nothing to explain here. What can I explain? This is the figure, this is the fact. Then, qualification. To be the chief election commissioner, to be the election commissioner, what is the qualification required? No qualification required. Nothing. Zilch. Zero. Any person chosen by the president can become the election commissioner. Yes, one thing which is important is that the service conditions cannot be varied to the disadvantage. That can't be done, right? So that is there. that the service conditions can't be varied to your disadvantage. That is there. Uh, Apart from it, one very big problem that is there with election commissioners. Now, see, the appointment of election commissioners is done by the government. Removal is different. We'll see shortly what is the removal procedure. But the point is, if you are appointed by the government, you are more likely to give or maybe play favorites with the government. So, what happens is there is a small provision for a lot of posts, like say CAG. Now, CAG, we don't know what CAG's task is right now. Just a very generic task I'm telling you is that CAG performs the task of evaluating all the financial transactions of the government. Wherever and whenever government spends money, it's all evaluated by the CAG and the entire team, the Indian Audit and Accounts Department. Now, once CAG demits office, the tenure comes to an end, 6 years or age 65, whichever is earlier. The CAG is not eligible for any future appointment. That is why, if I am the CAG, I have no interest in giving any report in government's favor. I don't care about this. I will perform my tasks neutrally, because even if I come out of my retirement post, the government can do nothing for me. What can it do? The constitution debars me from no taking holding any kind of post. The same thing should be there for the CC also, the ECs also. Makes more sense that the constitution has debarred, but sadly, that is not the case. The constitution has not debarred the election commission members from future appointments. They're allowed actually. It's a very big loophole, right? If you are a UPSC member or a UPSC chairman or an SPSC member, SPSC chairman, the only elevation to post can be UPSC or SPSC. And once you have become UPSC chairman, nothing for you. End of story. But sadly, it's not the case for election commissioners, which is a big loophole. They should be debarred. They are not debarred right now. They can be appointed to future posts also. Anyway, now, what is the salary of the election commissioners and what is their tenure? Nothing is mentioned in the constitution. Are you able to understand it? It is not mentioned in the constitution. It is mentioned in the election commission conditions of service of election commissioners and transaction of business act. This act provides that the salary of election commissioners will be same as Supreme Court judge. So CEC or the ECs, they receive the same salary. Okay, they have the same power. In fact, same powers also. Why? Because all decisions in the election commission are taken by a majority vote. That is why same salary, same power, 2 is to 1. Don't think that CC has some special kind of power. No, no, nothing. Their term of office. Now, here, term of office, retirement age is 65 and tenure is 6 years. Tenure and retirement age, whichever is earlier, of course. Clear? Whichever is earlier. One more thing, simple question, yes or no answer. As per the constitution, the retirement age of election commissioners is 65 years. Yes or no? Few yes, mostly no. Okay, but yes, some people did not fail to disappoint me. I just mentioned it. This term of office is not in the constitution. It is as per this law, right? Jago, aspirant. Jago. Please. Now it is 9:30. Come on. Okay. Then moving on to one important element, that is removal. Now, removal is mentioned in the constitution. There is a specific clause for it. Article 324, clause 5 provides for removal. Removal of the chief election commissioner is similar to a Supreme Court judge. I think we had seen this yesterday only, right? So, same manner, same ground, special majority, all the nonsense applies here also. But look at the problem. The problem is other election commissioners. CEC has been guaranteed a security of tenure, difficult removal. But ECs, are they guaranteed the same security and assurance? Not really. The constitution says that the election commissioner's removal can be initiated on the recommendation of the CEC. On the recommendation of CEC. Is the recommendation binding? We don't know. What is the procedure? We don't know. Is there some voting required? We don't know. Can anybody else remove? We don't know. We know nothing. The only thing we know is that the CEC can initiate the procedure of removal, right? That's a problem with respect to the election commissioners. CEC and EC means what? Is a very complicated question somebody has asked. How do I respond to this now? These are the heartbreaking moments. CEC stands for Chief Election Commissioner and EC stands for Election Commissioners. Okay. So this is with respect to their appointment. No, Vivek, that's not possible. Right? So this is with respect to their appointment, number of election commissioners, salary, allowances, all these things, and of course, removal. Now, coming to a recently happened event in the country, Anu Barnwal case of 2023. So just a few months back, our honorable Supreme Court milords, they wanted some kind of provision for independence of the election commissioners. So in this Anu Barnwal case, the Supreme Court said that Parliament was supposed to make a law to provide for a procedure for the appointment of election commissioners. Where is the law? It's been 75 years, Amrit Kal. Where is the law? There is no law. It is biasness. Government can control the election commissioners. So the Supreme Court said, wait. We are here only. Article 142. Interfere everywhere. I mean, activism everywhere. Wherever things are a problem, we'll come there and solve the problem. So Supreme Court held that from now onwards, till the Parliament makes a law to provide for a proper procedure, the appointment of the election commissioners, including CEC, will be done by a committee comprising of Prime Minister. Makes sense. Leader of opposition, of course, in the Lok Sabha. Makes sense. CJI, add me also, because I am sitting free, idle, right? I have no pending cases in Supreme Court. Collegium task is fully complete. High Court vacancy is not there. I'm getting bored only. Add me also. So this is with respect to the appointment committee right now. So currently the appointment is being done by a committee comprising of Prime Minister, LOP in the Lok Sabha, and the Chief Justice of India. Clear? This is the same appointment committee which is used for the appointment of Director of CBI also. There also the CJI is a part of the appointment committee. Now, Supreme Court also said that it is desirable, though they have not given a judgment, it is desirable that the ground of removal of the election commissioners should be made same as that of CEC. So Supreme Court has asked the government, please, as of now, the election commissioners removal is very vague. So why don't we ensure that if these two people have the same kind of power, are getting the same money, everything is the same only, then their removal should also be the same. But as of now, nothing has happened. So this is a desirable feature which the Supreme Court wants the Parliament to be, which the Supreme Court wants the government to incorporate. Clear? Now, for some of our very eager and enthusiastic aspirants who are saying there is no LOP in the Lok Sabha, how will this happen? So, let me clarify. At any point of time, if there is no LOP in the Lok Sabha and in some appointment committee, LOP of Lok Sabha is required, Mavlankar criteria is ignored. Okay? What is Mavlankar rule? The real problem is the Mavlankar rule only, because that is a rule which is limiting the Congress from becoming the leader of opposition. 10% rule. So we ignore the 10% rule. We choose that person from that party which has the highest numerical strength in the Lok Sabha. Are we clear on this? Whenever there is no LOP in the Lok Sabha, Mavlankar rule is ignored and we simply choose the person from that party which has the greatest numerical strength in the opposition. Clear? Okay. And lastly, Supreme Court said that the condition of service of election commissioners shall not be varied to his disadvantage after the appointment. LOP means leader of opposition. Done with the Election Commission of India basic provisions. Solve this very complicated and a difficult question which was asked 21 years back. Please mark an answer for this question. I think this is a first question for the day. Okay, a lot of you mark this as correct. Others mark this as wrong. Amazing. Let's see where you made the mistake. The CC and the other election commissioners enjoy equal powers but receive unequal salaries. They receive equal salary. Same as Supreme Court judge. One is wrong. Remove these two. Good old days of elimination. Two is correct. Don't mark it as wrong. It has to be correct. Okay? So two is correct. The CEC is entitled to the same salary as Supreme Court judge. Now 3 or 4. Let's look at 3. The CC shall not be removed from his office except in like manner and on like grounds as a judge of Supreme Court is correct. So B is the right answer. The term of office of election commissioner is 5 years. It is not 5 years. It is 6 years. Or till the day he attains the age of 62 is also wrong. It is 65. Okay. So 4 is also wrong. Right answer is B, 2 and 3. Now let's come to functions. These two are the primary functions of the Election Commission of India. Article 324, Clause 1. Before the appointment, which is Clause 2, we have the functions, Clause 1. So what are the functions of the Election Commission of India? Prepare and revise the electoral roll. What is electoral roll? Electoral roll refers to voter list, right? Kids, noobs will call voter list. Legends use electoral roll. Use complicated terms, confuse everybody. So, prepare and revise electoral roll. Voter list is updated by the Election Commission of India. So, every year people die, people turn 18, people leave this country, go to some other country, people leave an area, go to some other constituency. So, the voter list before every election needs to be updated. ECI will update the voter list. Second, conduct and supervise elections to the Lok Sabha, to the Rajya Sabha, to the Assembly, to the Council, for the President, for the Vice President. Every election in this country is conducted and supervised by the Election Commission of India, except, only exception is which elections? Tell me. Yes, elections for local bodies, because there we have Article 243 capital K, State Election Commissioner, the only exception. No role played by the ECI in the elections there. An independent body, State Election Commissioner, who is removed in the same manner as a Supreme Court judge or a High Court judge. And let me just clarify, it is a constitutional imperative that the ECI conducts free and fair elections. Supreme Court's statement in the MS Gill case of 1978, right? Then to fix the entire election program. This is mentioned in one RPA. We'll discuss RPA maybe today only. We'll start the discussion on RPA today, but RPA 1951 we'll discuss tomorrow, on Monday. So section 30 of RPA talks about the election program. Now you will say, sir, what is election program? Please tell me. Don't panic. Just like you have a UPSC program, UPSC announces that next year in the month of February, the form filling will start. Then half the country becomes excited that, okay, let's fill up the form. Form is very cheap, free for some, national pastime. So first step is announcing the election. So election is announced. Announcement. This announcement is done by the ECI. Next, once the date is announced, within 21 days, within how many days? 21 days, the notification has to be released. Official notification is published in the Gazette of India on details of when and how of elections. So this notification is released by the president or the governor. Okay. It's like your form filling date has started. The time begins. So some time is given for our candidates to fill up their nomination form. Nomination form. How many days? 7 days time to file their nomination paper, meaning filling up their form, their details, how many pending criminal cases are there, education qualification, etc. All these details. Once this is done, just like for UPSC, what happens? The UPSC will scrutinize the forms. In fact, most people don't understand that's the first level of rejection. If you cannot fill up the form properly, with folded hands, we are saying, please don't become IAS officer in future. Anyway, so UPSC also scrutinizes your form, rejects some applications. Here also, the Election Commission of India will scrutinize the form. So, scrutiny of nomination takes place. Once this is done, then some time is given. 2 days time is given. 2 clear days of time is given for what? For any candidate to withdraw their nomination. So some candidate feels, no, I cannot speak in public. I'm feeling very shy. Or somebody says, I can't lie so much. I mean, I cannot present my speech so much. I cannot give false promises and all to people. so I won't take part in elections. Like all those people, right? The innocent people. One fine day, the police caught you in the traffic without a helmet and scolded you, maybe slapped you also. You're very angry. You go back home. I'll prepare, become IPS officer. You fill up the form also, and then you see the syllabus and you see the PYQs, and then you say, sorry, by mistake, it happened. Right? So those people don't come for the prelims examination. Right? So withdrawal of nomination. Once this drama is over, then you can start the campaigning. But 14 days of time must be given for campaigning. So minimum 14 days. And here the polling begins. Now the polling begins, the polling continues. Depending on which state you are in, if there's a bigger, larger state, then of course it'll take more time for polls to be conducted. If you're in a smaller state, within a couple of days or one day only, the polling will be over, right? Okay. And finally comes the date of declaration of result. And we choose who is going to harass us for the next who is going to govern us for the next 5 years. Okay. That is all as far as the entire election program is concerned. This entire program is fixed by Election Commission of India. Are you clear, everyone? Okay, nothing much to explain. This is just a procedure followed. Now, uh, please tell me the first point. This is an article of the Indian Constitution. Of course, some of you will have no idea, but others who know, please mention the article. Some of you who are performing the very uh, abhorrent task of revisions on a daily basis would know. Which article is that? Okay, very good. This is Article 103. The disqualification of our legislators when it comes to the president, 103, for the governors, 192, right? So we can write like this. For the president, it's Article 103. For the governors, it is Article 192. So whenever our MPs, MLAs, MLCs are disqualified on the grounds of not being a citizen, office of profit, unsound mind, bankruptcy, etc., then the president decides for MPs and the governors for MLAs. But on the advice or the binding advice of the Election Commission of India. Okay. Then the ECI also prepares and revises, updates the Model Code of Conduct. What is Model Code of Conduct? Ignore it for now. Once we are done with the RP and stuff, we'll discuss what is Model Code of Conduct also. Then the Election Commission of India also manages an institute called IIDEM, India International Institute of Democracy and Election Management. Basically, this institute is a training ground. Provides training for EC officials of other countries, Uganda, etc. I don't think that USA, UK they will come, right? So these this institute provides training to election commission officials of some other countries. Okay, then examining the accounts of expenditure submitted by the candidates. So this is as uh, per the provisions of RP only, that whenever you are conducting, whenever elections are conducted, every individual and political parties also have to submit election expenditure. What was the money you spent in purchasing votes? I mean, in spreading information on election, in campaigning, right? You have to give entire detail of the total money you spent in the election. Account of expenditure submitted by candidates plus the political parties also. And this is done within 75 days of the completion of elections for the Vidhan Sabha, within 75 days of completion of elections in the state legislative assembly, and within 90 days of the completion of elections for the Lok Sabha. Okay, so you have to submit the entire detail of money you have spent as a party and as an individual. If you don't, you can be punished with disqualification also. Now, it decides the criteria for recognizing parties. So there's a law called Election Symbols Reservation Allotment Order. Under this law, the Election Commission is the competent authority to decide uh, on the tag to be given to party. So based on the performance of functions in our country, parties are given some tag. You'll study more of this in your governance classes. Just basic information. So political parties are of two kinds, not good and bad, but those parties which are registered and those which are unregistered. So unregistered parties cannot contest elections. Registered parties can contest elections. Just like you have two aspirants, aspirants who have filled up the form, who have not filled up the form. Okay, once you have filled up the form, you can take the exam. Based on your exam and based on your performance, you can be called useless completely, unrecognized, or you can be recognized by the ECI based on good performance. Just like if your performance as a party was very good across the country, you are given the tag of a national party. If your performance is good in some states, you are given a tag of a state party. Just like if you have cleared the prelims a few times, if you have cleared the prelims, you will be called a prelims cleared candidate or a mains cleared candidate. And once you get the tag, then you have every right to give useless information to the upcoming aspirants and spoil their life also. I mean, giving right pointers to the upcoming aspirants. Okay. So this is the function of giving recognition to these parties. In fact, it is the election commission only which also looks into any kind of disputes on the election symbols. Who allocates election symbols? Election Commission of India. Not just this, plus mergers, splits, all decided by the Election Commission of India only. Right? So now don't think that you can choose any random symbol, right? It's not some tattoo drawing that you can choose, pick and choose. Go on Instagram and Pinterest and download some photograph. You have a list of symbols prepared by MSAT, and you can choose from those basic items only, because those symbols have to be replicated on the EVM also, right? So all these things are there. Now, lastly, a very important element is fixing the limit of poll expenditure. So for parties, there is no upper limit. But for individuals contesting election, there is an upper limit. This limit is mentioned in one Rule 90 of Conduct of Election Rules of 1961. In this particular Rule 90, limit is there. In every constituency, a person contesting elections cannot spend more than a certain amount. I know you may find it funny, but that is there. Limit is there. What can we say? For Lok Sabha, the limit is rupees 95 lakhs for larger constituencies, larger ones. In large states, and rupees 75 lakhs in the small states. For Legislative Assembly, this limit is how much? Rupees 40 lakhs and rupees 28 lakhs. I know, some of you will say this is just a joke. It is actually, right? Uh, on most occasions, people do cross this limit. If you cross this limit, let me remind you, you can be disqualified for 3 years if you're caught, that is. So the point is, our former Prime Minister Atal Bihari Vajpayee, once in the Lok Sabha, had said that every MP in this country begins his or her political career with a lie. And the lie is the affidavit that he has controlled his expenditure within the limit. And let me remind you, this limit was only 70 lakhs 2 years back. It was increased to 77 and now 95. And for Vidhan Sabha, it was only 28 lakhs. He increased to 30.8 and now 40. 28 lakh rupees in a Vidhan Sabha election. Really? Association for Democratic Reforms, in one of its report, had said that in 2019 elections, there were over 80 such constituencies out of 543 or 542 where elections were conducted actually. 80 such constituencies where the average spending per candidate was how much? 40 crore rupees. Yes, 40 crore rupees. That is why the number of crorpatis in the Lok Sabha 2019 was upwards of 470. More than 470 MPs were crorpatis, with an average asset of these crorpatis as 20 crores. Right? Imagine when you spend 40 crores to win the election, the amount of pressure on you to recover the money, right? And imagine if you have spent 40 crores and have lost the election. Next time, they double the pressure to earn the money back. See, people also are at fault. We, you know, are demanding more and more. 20 years back, normal voter could be bribed with one chicken biryani, one quarter bottle. Now people are demanding 5,000 rupees per vote, 10,000 per vote. So we also have increased our aspirations and expectations of demands. So parties saying, okay, how much money do you want? Take this. Please go and vote for me. So that's the beauty of the fair part of elections. So now when we say that elections are free and fair, yes, they are free. Free meaning the freedom of choice. When you go inside the polling booth, you can vote for any person you want. Nobody is watching. Fairness means equal chances of victory. Now, that may not be there. If this is the amount of money required to win the elections, at least from most of these NGOs and their sources, then not right to say that there is fairness. Equal chances of victory may not be there. Anyway, that is it with respect to the functions performed by the Election Commission of India. Right? Solve one very difficult question came in 2017. Why only individual candidates? That is the law. There is no limit for political parties because political parties campaign for the party in general in the entire country. And why would any political party fix a limit for themselves? So for individual it is there, but there is no such limit for political parties in general. How political parties earn money? They don't earn money, they beg for money. So political parties get money from donations. That's it. You and me and some rich businessmen, right? Sudanese, etc. We don't know who they are. They fund these parties. Okay? That's where they generate revenue. Okay, easy question. ECI is a 5-member body. Nonsense, absolutely complete nonsense. So ECI is not a 5-member body. One is wrong. Union Ministry of Home Affairs decides the election schedule. Election schedule is decided by the Election Commission of India. Home Ministry. Imagine Amit Shah deciding the election schedule. So C and B are also wrong. D is the right answer. ECI resolves disputes relating to splits and mergers of recognized political parties. Okay, so that's there. 3 is correct. And no emojis when Amit Shah's name comes, right? Everybody is afraid of their life. We should be. So, this was the question. Now, RPA 1950. What is RPA 1950? What is RPA 1951? Why do we have two laws? No, people, before you ask this question, why two laws? Why not only one law? Confusing for aspirant. That's true. That's true. But the former Chief Election Commissioner, S.Y. Qureshi, in one of his books, The Great March of Democracy, mentions that he's also been asked this question. Why do we have two laws? Why not only one law? To which he responds, I don't know. If the former Chief Election Commissioner says, I don't know, don't expect a polity faculty to know why we have two laws. If you want me to create an answer, I can create an answer. We have two laws to ensure that one law, RPA 50, deals with voters and delimitation. 1951 to deal with the other matters of candidates and the actual conduct of elections. That's why these two laws deal with different matters only. My request to you would be mug up this statement, this entire phrase. Please mug up this phrase. If a question is asked on RPA 50 or 51, then you can simply in the intro write this, vomit on the paper, this only. RPA 50 deals with allocation of seats, delimitation of constituencies, qualification of voters, preparing the electoral rolls, and the manner of filling seats in the Council of States. Clear? Now, what provisions under RPA 1950? This is the entire RPA 50, various chapters, various sections. This slide not important. Ignore it like you ignore some people in life. Then coming to this particular slide, you already know this information. Trust me, you know this because we have seen this information. You would not remember. Allocation of seats. How many seats are there from each state in the Lok Sabha? This information, and how many seats are reserved for SC STs. This information is under Schedule 1 of RPA 1950. How many seats are there for every state in there, or how many seats have been allocated to every state in the assembly? This is mentioned under Schedule 2 of RPA 1950. How many seats will be there in those states which have councils in their councils? This is mentioned under Schedule 3 of RPA 1950. One small question. How many seats are there for each state in the Rajya Sabha? Allocation of seats to Council of States. Where is that mentioned? Allocation of seats to Rajya Sabha is mentioned where? Schedule 4. Very good. But not under RPA of the Constitution of India. Okay? These three: RPA, RPA, RPA. Clear? Also, one more point. Uh, the number of SC/ST reservation in Rajya Sabha is mentioned where? In the Constitution or RPA? Tell me. Number of seats reserved for scheduled caste and scheduled tribe in Rajya Sabha is mentioned where? In the Constitution or RPA? Okay, some of you have been trapped completely. Others are right. There is no reservation for SC/ST in the Rajya Sabha or the council. Reservation for SC/ST is limited only to the what? Lok Sabha and the Vidhan Sabha, the directly elected houses. Moving on. Now, RPA full form. RPA full form is Representation of People's Act. How? I mean, I'm sure if this was an offline class, this question would never have been asked. I mean, of course, you would not be sleeping only, but anyway, now it's 10 o'clock. Come on. 10 o'clock, still sleeping? Late night, Friday night party. I had told earlier also, don't party Friday night, party Saturday night. Okay, so now coming to the officers under the uh, law, whose task is it to look into the election procedure. Election Commission is a very small body, right? But they take government staff on loan, on deputation to conduct elections. So in every state, you have a person called Chief Electoral Officer, CEO. Then in every district, a DEO is there. Then for every constituency, we have a person called Returning Officer. Why is he called returning? What is he returning? He is returning to the people of the constituency a winning candidate. The returning officer is the officer who is in charge of conducting elections in the entire constituency, right? This person is basically an IAS officer only. So normally, the returning officer for Lok Sabha is the district magistrate, and for the assembly is the sub-divisional magistrate or the sub-divisional officer. Okay, so if some of the people here who are putting in the effort, not sleeping too much in the class, and they clear the examination, they will become a DM, initially an SDM and all. And in your state, if elections take place, you'll be given the charge of conducting elections in your entire constituency in the Vidhan Sabha. Right now, you are having a drama of understanding RPA. You'll have to conduct elections on your own, and nobody will come and teach you that what is the step. You have to learn on the go. That's the beauty of the training, capacity building. Learn while you work. Okay. One more thing. Apart from this, we also have the concept of polling booth. So an entire constituency is divided into small areas with one polling booth, so that voters can be segregated and a group of voters can go and vote in an area without wasting much time. Polling booth. One small question: how many of you have ever voted in the elections? Yes or no? 10 seconds. A for yes, B for no. Take the poll, it's okay. Oh, a lot of you have not voted. So you would have no idea. The only alternative is believe me. What I say, believe me. Okay, so polling booth. So what happens is, see, some of you, I'm sure, would have not voted because of not being of the required age. Others may not have voted because of multiple reasons. So when you go to a polling booth, this is a small area. In a colony, they'll set up a polling booth. The polling booth has maximum, that's the upper limit, 1,500 people. So this number can be modified. This number can be modified. Okay. Then election commission normally says that their idea is that people should have ease of voting. So every person should have a polling booth ideally within 2 to 3 kilometers of his place of residence. Ideally, 2 to 3 kilometers. Now, in this polling booth, there are some officers. When you go to the polling booth, the head of the polling booth is called the presiding officer. And along with him, there are other people who are polling officers. Polling officers can be of various categories: micro observers, they can be cameramen. These people manage one polling booth. And who are these people? These people basically are government employees, teachers, bankers, etc. Okay, these are the people who are taken by the election commission on deputation for a couple of days of their service. They are paid money also. It depends which polling booth you are performing the task, what role has been given to you. It can range from around 7 to 800 rupees to even 2,500 to 3,000 rupees of that day of work. It depends. And who decides that? The returning officer, district magistrate, SDM. You decide that, right? So this is with respect to the polling booth. Clear? So when you go to the polling booth, you have a lot of people there. One person has control of the EVM who presses the button and then you press the button, right? That person is the presiding officer. So for those who have voted, when you go to the polling booth, there's a person who controls the EVM. If he presses a button, then you press the button and the vote gets registered. Only one vote, right? Then there are people who put in the ink on your finger. Then there are people who put in the who match your name with the voter ID card name, etc. All these things. So all of them are polling officers. Now we had discussed earlier that election commission updates the voter list. ECI is a handful of people. Do you think the chief election commissioner comes to your house, says anybody turned 18, anybody passed away with a voter list? Of course not possible. So election commission thought how to update this voter list. So since 2006, they have come up with a very unique way to solve this problem. There's a person called booth level officer for each polling station. Polling booth or a polling station, same thing. A polling a booth level officer. They are basically some local government employee, member of some panchayat, local body employee, etc. So government or a semi-government employee, and this person is given the task to update the voter list. Now, since he's a government employee, if he gets involved in any hanky-panky activity, then his government job can come under the scanner radar of ECI. There could be some problem, right? So then local body officials, they can also be made BLOs. So ideally the point is that if you are the local person there, you have a better chance of knowing things factually, and you can update the voter list with adding new names of voters who have now turned 18, people who left at the area and have changed their name from this list to some other constituency, people who passed away, their names have to be removed. So updating the voter list, right? So they are the ones who are actually involved in the collection of field information, etc., right? And think of them as the representatives of ECI at the grassroots level, and that's why we call the BLOs as a friend, philosopher, and guide to the local people. Okay, booth level officer. That's it with respect to the officers. That is sufficient information. No research is required. Finally, coming to types of voters. So we have three types of voters. One, of course, is the general voter. Then we have service voters. And then non-resident Indian, NRI voters. NRIs, remember? Those people who go to a foreign country and then come back with a changed accent and a Bisleri bottle. NRIs, same people. NRI voters. So various types of voter are there with respect to various voting rights given to them. So as I said, number one, you have general voter. General voter is somebody who's given the right to vote, but when you are a general voter, you come to the polling booth and cast your vote. Physical voting. For general voters. Number two. Now, here we have service voters. Now, service voters can be of three kinds. Number one, service voters can be people employed in the armed forces, the police serving outside the state. Okay. And number three, Government of India employees. Outside the country. So all IFS officers who are there, they'll be posted outside the country. So you are all covered under the category of what? Service voter. For service voters, there are two options. Either you choose physical voting, which is of course there, or you choose the alternative called postal ballot, or you choose proxy voting. What is postal ballot? You get a ballot paper form, fill up the form, mark your preference, and send it via post to ECI's office designated address, and your vote is registered. And proxy voters, what is proxy voting? Proxy voting means you appoint somebody else on your behalf. That person will go to the polling booth physically and mark the vote on your behalf. Physical voting. Uh, just like your college days, you sit in your house enjoying life, or out somewhere with your friend roaming around here and there in some garden or park, and your friend in the class will mark the attendance for you. That is what is called proxy voting. What is physical voting? Physical Physical voting means you go to the booth personally and are present on the polling booth to cast your vote. That is called physical voting. What is your point of discussion here? This is physical voting. So, as a service voter, you have both the options. But if you choose to be a non-physical voter, then you cannot go and be present personally. If you have chosen proxy voting, you can't go personally. Then you have to rely on proxy voter only, right? Proxy voters. Who are these proxy voters? Proxy voters, anybody who you have reposed faith and trust in can go and cast the vote on your behalf. Of course, you have to disclose the name of the your choice to the proxy voter. Ideally, your spouse would be a proxy voter, right? Especially for the armed forces and police, etc. Spouse is a proxy voter. So your spouse goes and casts the vote. Now there is no way of knowing whether the spouse cast the vote in favor of the person you told him or her or not, right? You have to have faith and trust in the person you love. As simple as that. If there is no trust there, then what's the point of marriage? Sir, can girlfriend be proxy voter? Yes, girlfriend can be proxy voter for you, Mr. Vivek. But again, if you are a BJP fan and she goes to the polling booth and finds Rahul Gandhi cute and votes for Congress, you'd have no idea that your vote has gone for Congress. Let me be clear about this. What about IAS officers outside the state? IAS officers, we'll come to that. We'll come to government employees later on. Don't worry. Third category, as I said, was NRI voters. For people here, let me clarify. NRI is any person who is living outside the country for more than 182 days, or any person who resides in India for less than 182 days in a year is called an NRI. But he's an Indian citizen, so has the right to vote. So NRIs, of course, can vote physically, physical voting. Come here and cast your vote. But see, if you are in Nepal or Bhutan or Sri Lanka, Myanmar, even Pakistan, firstly, what are you doing in Pakistan? But still, if you are there, you can come very easily. But if you are in Australia, USA, and all, coming back here and voting, wasting 1 lakh rupees in one way trip, 2 lakh rupees for one vote. Come on, let's be serious. Most people will not be able to spend this money, right? So there is also a concept of e-postal ballot. Since 2015, Supreme Court's instruction. So Supreme Court instructed the ECI in the Nagendra Chindam case of 2015 to please allow the NRIs to become to be eligible for e-postal ballot. So what is electronic postal ballot? What is the electronic part? Don't think of it as online voting and all. It is not online voting. Are we clear? Let me clarify. There is no online voting. It is not possible. It is not Indian Idol. The sites of these international organizations get hacked within minutes. If ECI makes a website, it will be hacked in seconds. So that's not possible. What happens is, the electronic part. Electronic part is that you are made available the ballot paper in an online PDF form, downloadable form. Download the ballot paper, okay, mark your preference, send by post. So the downloading part is what is the electronic part, right? That's it. Now, even this e-postal ballot is yet to be implemented. But however, yet to be implemented. Election Commission says it requires amending the conduct of election rules, etc. It's a challenge right now. Various parts of the world, people will be sending their votes, right? So it may not reach the ECI's office in time. So all these issues are there. We have one fourth category of voters called absentee voters since 2019. Absentee voters are basically voters of three categories. Number one, people employed in essential services, doctors, etc. Number two, persons with disabilities. Persons with disabilities. Number three, senior citizens, but above not 60, above 80. Above 80. These three come under absentee voters. For absentee voter, what provision do we have? For them, the provision is of postal ballot. Postal ballot. So under section 60, subsection C of RPA 51, we have absentee voters also, which is with respect to what? The people who may be employed in essential services, physically handicapped people. So this is again innovation from Election Commission. We are trying to find out ways to incorporate more and more people as voters. And of course, what's the criteria? What is the criteria for registration as a voter? The criteria is very simple. One criteria is citizenship. The other criteria is, of course, age. And third criteria is you have to be an ordinary resident of that particular area. That's it. Okay, and migrant voters, RVM, remote voting, that is just in a nascent stage. The Election Commission has tried to talk to IIT Madras people, and they are coming up with some concept of remote voting. for migrant laborers, students, etc. That is in the very nascent stage. They'll be using the blockchain technology to incorporate, look into whether remote voting is possible or not. So that is there. That's it with respect to the types of voters in the country. And that's it for today. Let's not stretch beyond this. Let's end our discussion here only today. So please, today and tomorrow, don't waste time. Revise the PPT, take the mock test, solve the PYQs, and revise the entire week's PPT. Okay? Monthly magazine, you have to study every day. That's it. And if you still have time, follow Yojana Kurukshetra, 2 articles each from Yojana today, Kurukshetra tomorrow, or vice versa, whatever you are following. Right? Apart from it, you can also, if you still have time, read political theory, the next chapter revision. Okay, so that's it. Also, the class timing is 6 to 9:30 only. Don't come at 7 on Monday saying, sir, class had it started at 6 only. The class timing is 6 to 9:30 only. Because it was a Saturday, so we started at 7. Clear? 6 to 9:30 on Monday. Don't enjoy your sleep and wake up at 7. Leaderboard makes no sense of leaderboard. I actually gave a poll where I had to mark a right answer. So leaderboard makes no sense today. Okay, that's all for me, guys. Jai Hind. Questions, doubts? Uh, Again, I'm telling this again and again. See, if anyone here is taking the exam in 2025, 26, etc., skip the monthly magazine. That is why, Dinesh, for Government of India employees, we also have proxy voting available, right? Do Naxals also vote? Who is a Naxal? How do we know? If he is an Indian citizen, she's an Indian citizen, they'll vote, or else will not vote. If you are in jail, you can't vote. Lok Adalat is a place for compromise. Tribunals are like courts. They give awards, orders. A versus B. A wins, B loses. It's not a compromise. Yes, yes, others can leave, enjoy life. Ordinary resident is requirement for being a voter, not a candidate. Great, Gauri. Amazing. Good going then. Revise the videos. See as to what can be done. Let me know if there's some specific problem. Generic statements, how will I respond to a generic statement like that? Yes, Palak, you can use them to solve answers. Deepson PYQs from the PPT is available. UPSC website, previous year questions. Yes, Harshit, they provide advocate. Jan, we will discuss that tomorrow when we discuss further the right to vote concept, or on Monday. Yes, Sanchit, convicted person can contest elections. Bhagya, no, your voter ID card and the form is required. Nothing else is required. Smriti, normally they are the same thing only, but the original jurisdiction, the exclusive one, is what is actually called the original jurisdiction. Okay, so is it important to see my workshop? It was meant for beginners. So if you consider yourself as a beginner, you can. PYQs of mains, prelims we're discussing already, and solve for prelims also. Mains, answer writing. Shriman, the balance of both are required because revising PPT becomes boring. So you have to also solve MCQs. Shargun, ignore it. Don't worry. Study right now. The same basic documents. And if you don't have any document, no problem. You sit for the exam, take the exam, clear the exam. Once you are selected, they'll then require the documents. No, Sachin, that is not available for lower courts, but Supreme Court and High Court, they can issue content for lower courts also. Soumya, postal ballot? Yes, Soumya, that is correct. Meenachi, standard should be 8 to 10 pages, but anywhere between 5 to 10 is also okay. No problem. How can I cover current affairs for 2024? By studying on a daily basis. Arun, we'll discuss that tomorrow. What will happen? You can be disqualified for 3 years from contesting elections. Postal ballot is when you post, you mark your preference in a piece of paper and send it via post. Secret ballot means your voting is not revealed to anyone. So when you go to the polling booth and press the button, nobody sees who you're voting for. That's called secret ballot. ARC report, what is it to understand? It's a recommendation. How can you not understand recommendations? Okay. Yes, Bhavik, that's possible. Ocean, not right now. We don't really know that there is a defection because the problem is splits are not allowed. And that is why every party, within the party now, they have this new drama that I am the real party. Split has not happened. I am not leaving. I am the real boss. Right? That's it. Okay, that's all for me for today, guys. Your experts can keep on addressing your concerns if you have any. We'll meet day after tomorrow to continue our discussion further on the elections, RPA 51, other electoral issues like compulsory voting, etc. And finally, we'll be moving into the first part of the Indian Constitution, Union and its territories. That's all for me, guys. Jai Hind.